So, Jay, a judgment was handed down this month from the High Court by Judge Humphreys. This was a case of Thomas Reid and An Bord Pleanála. So you're going to take us through what the judgment means. First of all, in a nutshell, what was the judgment about?
So in a nutshell, the judgment was about whether evidence or grounds that were not brought before the decision maker, so in this case, An Bord Pleanála, whether those evidence or grounds could then be brought before the court. Justice Humphreys said that although it's quite a minor procedural point, it really goes to the heart of what judicial review is all about.
Okay, brilliant. Would you mind giving us a bit of background about the case, so the actual development that was in question?
Sure. So Intel Ireland Limited, who are the developer, they applied for planning permission for a plant. I think the cost of the plant, the construction costs are about 3.7 billion euros. Planning permission was granted. The developer then appealed that to An Bord Pleanála, as did Mr. Reid. An Bord Pleanála granted planning permission on the appeals. They allowed the appeal subject to a lesser number of planning conditions than the original planning permission. Mr. Reid then challenged that decision in the courts, and Mr. Reid is a farmer who owns land adjacent to the development site. With his application, he lodged 7 affidavits, a couple from a research scientist, and the developer then basically lodged an application to exclude the majority of the information in those affidavits.
Okay. So when will a court not allow new evidence or grounds to an appeal like this?
So the general proposition comes from a Supreme Court case in 1998, where it was held that evidence or grounds that were not brought before the decision maker, that they can't then be brought before the court, basically, because that would be unfair on the decision maker. Those evidence or grounds should be brought before the decision maker first. Now that point's being developed in this case slightly further. So the judge gave for a few circumstances where evidence or grounds basically can't then be brought before the court if they weren't brought before the decision maker. So they relate to matters like special procedures or evidence that the decision maker wouldn't have ordinarily known about.
So these instances seem to broadly relate to new evidence or grounds that the board would not be expected to have known about when it made its decision, or that maybe are irrelevant to the matter. Do you have any examples?
Yeah, that's correct. So an example in this case, the judge gave relates to the Habitats Directive. So under the Habitats Directive, a development which will adversely affect the integrity of a European site is not allowed to proceed, but that's subject to limited circumstances. And there can't be any doubt on that potential impact on the European site. So if an objector has evidence that could have casted doubt on that assessment, and it's, let's say it's new scientific evidence that the decision maker wouldn't have ordinarily known about, that evidence really should have been brought before the decision maker first. It can't then be brought before the court.
That makes sense. It seems fair that this kind of information can't then be brought before the court if it's not before the decision maker. But there are certain circumstances where this information can be brought before the court. So when can a judge allow new evidence or grounds that were not before the board?
So in this case, Justice Humphreys gave 16 circumstances. I'm not going to go through each of them here, but yes, there are circumstances where evidence or grounds that were not brought before the decision maker can then be brought before the court, but those relate generally to procedures or the decision making by the decision maker, in this case An Bord Pleanála, that you would have expected them to normally take under their statutory powers. Or let's say if a decision was wholly irrational, or the decision maker didn't give proper reasons. So an objector really wouldn't have known about that at the time that, you know, that they were lodging their objection, but once the decision's made, they would become aware of, you know, of this illegality, so to speak, and then they can bring that evidence or those grounds before the court.
So broadly, aside from maybe a couple of specific points, this seems to be generally about the board not acting as it would have been expected to based on the information in front of it. The objector can provide evidence or grounds before the court to demonstrate this. Do you have any examples?
Yeah, so a couple of examples in this case are, well, one that comes to mind straight away is to do with evidence that the objector had basically clarifying technical terms that were before the board when it made its decision. So this kind of that evidence or that information just provided kind of further clarity on that information for the decision maker, and in that case, the court allowed that evidence.
Okay, so would you say that this approach by the court is fair?
I think it is quite fair. I think it's quite a balanced decision because, generally speaking, an objector who has informational grounds, they should really bring that before the decision maker first. I think that would allow the decision maker to then ask for further information from the developer, let's say, and the developer has a chance to address those issues, and it gives a kind of more robust planning application process or planning appeal process. But on the other side, an objector may not know about the decision maker acting irrationally, let's say, until that actually, of course, happens, or if the decision maker doesn't act within its powers or doesn't give proper reasons, that will only happen at the time of the decision. And in those circumstances, it's fair for an objector to raise those points then with the court.
Okay, thank you, Jay. That was really informative for developers, especially when they're looking at what kind of information they provide to the board, and also throughout an appeal, like what information they can provide to the court. For more information on successfully navigating planning laws, please visit our website and subscribe to our channel.